A. And Mr. West, as soon as you're ready, we'll get the jury back in. And
yes, sir.
I wanted to address the issue of 9616 before.
I wanted to do it after
finish it. Yes,
after openings, yes. Okay, we'll bring the jury in.
The jury is present.
Please be seated. Welcome back, ladies and gentlemen. While you're getting your notepads and selves settled in, I'm going to ask you the questions again. If your answer is yes to any of my questions, please raise your hand. During the lunch recess, did any of you have any conversations amongst yourselves or with anybody else about the case? No hands are being raised. Did any of you read or listen to any radio, television, or newspaper reports about the case? No hands are being raised. Did any of you use any type of an electronic device to get on the internet to do independent research about the case, people, places, things, terminology? No hands are being raised. And finally, did any of you read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case? No hands are being raised. Thank you, Mr. West. You may proceed.
No more bad jokes, I promise that. I'm convinced it was the delivery, though. I really thought that was funny. I'm sorry if I offended anyone about that. Mr. Guy made several statements to you this morning that were passionate. They were obviously passionate. They were said strongly, but without much detail to back it up. My focus is on the detail, and if I have to sacrifice passion, it's not because I don't feel passionate about this case. It's been my life's work for the last year. But it's because I don't want that to get in the way, even if it means it's boring or somewhat technical. I want the information before you that you may consider in evaluating the evidence. I want to talk with you about specifics. The thing that Mr. Guy said so passionately, but yet so wrong, is that George Zimmerman pressed the gun into Trayvon Martin's chest. Before we broke, I said I wanted to talk about forensic evidence. I do want to talk about forensic evidence because that's science. You can hold your hand around it. You can examine it. It's not subject to bias if the experts are qualified. It's real. It doesn't change. So here's the science around the gunshot. It's fascinating, I submit. The hole in Trayvon Martin's hooded sweatshirt was a contact shot. You will know that because the fabric is somewhat shredded. The undershirt, he had a second shirt on. The fabric on it was also somewhat shredded. That's how a ballistics expert can tell, among other more scientific tests, I suppose, that it was a contact shot. What that means is that the muzzle of the gun was in contact with the fabric. So instead of a hole, a nice clean hole that you would get if you shot from a distance, the gases exploding, the hot gases, burning gunpowder, all of that tears a big hole in it. Contact shots, be they in fabric or be they in skin, are not very hard for an expert to know. It's an obvious call. Not going to be any dispute about that. The shot in the clothing was a contact shot. Why that is so fascinating and so important is this. The bullet hole in Trayvon Martin's skin was not. It was a very round hole made by a bullet. It had, they call it the ring abrasion, and it had a 2x2 area of soot or stippling or tattooing, 2x2, something like that. And what that means is this. As the hot gunpowder that's burning exits the muzzle of the gun, it burns whatever it hits. It leaves marks. That's why they call it the tattooing or the stippling. It's not gunpowder that wipes off. So with the 2-inch by 2-inch area of this stippling or tattooing, and it not being a contact wound, that means this irrefutably. That the clothing Trayvon Martin was wearing was separated from his skin by at least a certain amount, an inch or 2 or 3. Maybe not can tell that precisely, although I suspect that you can get pretty close with an expert that knows what the 2x2 means, because the gunpowder has to come out and burn. So we have this. We have a contact wound with, or a contact with the fabric, and not a contact with the skin. So then you would say, I would think, how could that happen? Here's how. Just the way John Good saw it. He saw Trayvon Martin straddling George Zimmerman and leaning over him, hitting him or punching him or pushing him. When you lean over, gravity pulls the fabric away. It separates, not like this, but like this. And you might say, well, how could that really happen? We know it did, first of all. But secondly, there's one other big piece of evidence that fits together perfectly that shows that John Good saw these two men in the position at the time. The way John Good described the position they were in when he saw him was the same position they were in when the shot was fired. And that is this. Do you remember the 23-ounce can of fruit juice by Arizona? Do you know where that was? It was in the front pouch. It was in the hooded sweatshirt in the pocket. That's where it was recovered. So in addition, we have not just leaning over, but we have extra weight in the front. we have a mechanism that explains that. Trayvon Martin's leaning over, straddling him MMA style, the ground and pound. George Zimmerman is crying for help. No one's helping. And he's finally able to get the gun out and shoot. And when he does, he doesn't even push it into his chest. He just gets it out enough that it touches the fabric. He didn't push it in his chest to pull the trigger. Even then, he got it out from his right side. You may have seen George Zimmerman writing left-handed. In case you did, he writes left-handed. But he does just about everything else right-handed. The holster is on the right side. That's how he shoots a gun. Has a permit. Has had a permit for a couple of years. Licensed and responsible. But yes, he did have the gun, and thank God. Because at that moment, he was able to retrieve the gun when he couldn't take it anymore, when he'd been crying for help for 40 seconds, when it appeared as though Trayvon Martin may be reaching for it even. After having his head bashed, his bell rung, his nose smashed, he gets the gun. And what does he do with it? He just raises it. That's all. He just raises it. As Trayvon Martin leans over, he pulls the trigger. Now, that matches exactly, scientifically, that the weighted front, the leaning over, the contact with the fabric, but not with the skin. And we'll have experts to talk about that, just so you know. If that ever becomes an issue, there will be experts talking about it, including Dr. DeMaio, that I mentioned earlier. Mr. Guy also mentioned that there was no blood on Trayvon Martin's hands at the time of the autopsy. That's somewhat curious, he points out, isn't it? In fact, though, at the scene at Twin Lakes there, Mr. Martin, of course, was on the ground. You'll see the pictures of him on the ground with his hands on the ground. You will know that one of the things that could have been done would have been to put bags over the hands. That's just a procedure so that the evidence is preserved, so whatever on there doesn't get wiped off or washed off or come off because it comes in contact with another surface. In this instance, maybe even the bag that Mr. Martin's body was placed in. That didn't happen. And when Mr. Martin was autopsied, the medical examiner did not photograph the palms of his hands to see whether there's blood on it or not. There are no photographs that they took that would show one way or another. There's no way to know, is that something that was there that got wiped off or didn't? Something that might have been seen even by staff but not noticed or particularly cared about because there weren't any obvious injuries to the palms of Mr. Martin's hands. Again, we don't have pictures. The pictures of Mr. Martin's hands that we have are only there to show the injury. The injury on this knuckle, a 1/4 by 1/8 abrasion, a fresh abrasion on his knuckle that we would offer evidence is consistent with him striking someone with his left fist. Would it have been George Zimmerman's nose? You'll have to figure that out as you hear the evidence. Could he have scraped it on the sidewalk as he bashed George Zimmerman's head? You can figure all of that out when you get the rest of the evidence. But that was the only injury to Mr. Martin other than the gunshot that the medical examiner noticed. Bruising is a little trickier because, as we know, Mr. Martin was shot in the heart, and he died very quickly. We'll talk to the experts whether one would expect bruising necessarily on the knuckles. I don't believe there was any specific testing done or any, what would you call it, a resection or something. I don't think that was done. But we'll find that out too. But there were no other injuries. No cuts, abrasions, that stuff. But back to the hands, because this is intriguing. One of Mr. Guy's statements was that Trayvon Martin was shown and seen at the scene with his hands under him clutching his heart. I will give you that the picture shows Mr. Martin's elbows out like this, and his hands may very well be under him in that picture. And indeed, it may be possible that he was even clutching his heart. But keep in mind this. If Mr. Martin was clutching his heart or had his hands anywhere near his heart where he was shot, there would be blood, wouldn't there? If the medical examiner had done that part of the job. So to say there's no blood in his hands really can't be true. It sounds more like the medical examiner not bagging the hands, maybe not paying particular attention, or perhaps even washing off blood just didn't connect that up. I submit to you, as you listen to the evidence carefully, that it's not significant, or at least it's not meaningful, it's not helpful in figuring out what happened. There's some DNA. There's some George Zimmerman's blood on Trayvon Martin's shirt around the waistband. There's some of Trayvon Martin's blood on George Zimmerman's jacket. Not a lot on anyone's clothing. In fact, when you see the photos, you'll see there wasn't a lot of bleeding on the clothing or beyond. The way they were positioned, and by changing positions so quickly, there really wasn't much opportunity for there to be much blood exchange. I think the evidence will show you that. But the absence of biological evidence or DNA doesn't necessarily prove anything. It's like if you touch something, I might leave a fingerprint and I might not, but it doesn't mean that I didn't touch it. There's also an additional problem with the DNA in this case regarding Trayvon Martin's clothing. It was, I suppose, a mistake. It certainly wasn't intentional, but nonetheless, there was a mistake made that may very well have affected the ability of the laboratory to do biological examination, specifically DNA. And here's what happened. We know it was raining. We know that Mr. Martin's clothes were wet. That's evident. In fact, you can see that in some of the pictures from the medical examiner. There's dark spots. They were wet. Everybody says they were wet. When you have wet clothing in a forensic setting, you're supposed to package it in paper to let it dry out, or let it dry out and then package it. You put it in a paper bag, it can breathe, it dries out, and the biological evidence remains intact. If you don't do that, then the biological evidence is subject to degradation. It degrades. And what happened is this. While it was a mistake, the clothing that Mr. Martin had was placed in plastic bags and sealed. It's sort of like putting wet shirts in your laundry bag, tying it up, or putting it in a plastic bag, waiting for a few days, and then opening up. It smelled like that. It's had that strong ammonia odor when something has been, fermenting. Maybe that's the word. The notes of the DNA analyst, his name is Anthony Gorgone, showed that in his notes, that there was a strong odor, mold, ammonia. It's clear that the clothes were packaged improperly. It's not clear, though, what significance that had on the evidence, that sort of knowing what you don't know, except it's a problem. It violates the guidelines for technicians in packaging clothing with biological evidence, especially wet clothing. But there is enough DNA to show that these guys were face to face, that there was an exchange. The gunshot proves, by virtue of the contact, that they were less than an arm's length away. That George Zimmerman didn't see Trayvon Martin somewhere over there and shoot him. That they were face to face, basically on top of each other. And the distance between the clothing and the skin shows that Mr. Martin was leaning over, precisely as John Good described what he saw when he walked out and knew it was serious. There's also another piece of evidence, calling it forensic evidence from the medical examiner, that corroborates what John Good saw. This is a photograph that was taken by, I think, Priscilla Feller, I think was her name. She was one of the assistants for Dr. Bell, Ben Dorton and Priscilla Feller. I think she's the one that took the pictures. And this is the picture of Trayvon Martin's pants. And what I'd like to point out to you and ask that you listen carefully about the evidence is the dirt on the knees. We know it was a wet night, rainy night, the ground was wet, and that John Good saw Trayvon Martin on his knees straddling George Zimmerman. This is circumstantial evidence. Remember we talked, I didn't actually, direct versus circumstantial. This is circumstantial evidence corroborating what John Good said. It's direct evidence of there being dirt on the knees. Let's also talk about some of the forensic evidence at the scene as opposed to at the medical examiner. And just to orient you here, what this is this is a poster board that was created as a result of the information collected through a system called Total Station. The Florida Department of Law Enforcement has it, or at least they did. They can go to a scene, they can set up the unit, and they call it shoot. They can shoot all these points, hundreds of points, that allows them to create and recreate exact measurements of where everything is. They can get the buildings, they can get all of this stuff. You can take that data then, and you can put it in a software program and recreate it graphically exactly the way that it was, mathematically exactly. That's what happened here. The fellow that created this, a fellow named Daniel Shoemaker, used the data that the Florida Department of Law Enforcement collected and then took the information from Diana Smith, the crime scene person where everything was found, and put it on this picture. The T, Jenna Lauer, Jeremy Weinberg, John Good, Mr. Manalo is here. There's a couple of things that don't offer much by way of help. A plastic Walmart bag, even the plastic 7-Eleven bag at marker 2, or even marker 4, the first aid kit. They were there in mark, but I submit they're not worth spending a lot of time on here. There are drain boxes and sprinkler boxes noted in exactly the position where they were. And then there's some very specific physical evidence. You'll see pictures of those in the trial, and you'll be able to determine the relationship. Because of the perspective on this, it's a little difficult to know how far this is, but for just our purposes, this from the T to these markers is roughly 30 feet, 30, 40 feet in that neighborhood. Marker number 6 is where Trayvon Martin's body was noted. Marker number 8 is a cartridge case. That's the spent casing. That was the shot. That was the shell casing, the shot that George Zimmerman fired right here. Right nearby was a cell phone that became identified as belonging to Trayvon Martin. There's also a flashlight here. Mr. Guy mentioned 2 flashlights. The evidence would suggest this was a flashlight that George Zimmerman had on him, perhaps in his pocket, but that it didn't work. On the other hand, there's no physical evidence connecting this flashlight to anything. In other words, there's no blood on it. There's nothing that means anything more than it's here. I think if you listen back to the recording of the non-emergency call, that if you listen carefully, you can actually hear some tapping of George Zimmerman trying to get the light to turn on as he's exiting the vehicle. There is a light that did work, though, and it was attached to his key. It was a little tiny flashlight, and when the police got there, they found it, and they found it on, attached to the key, right here. I would ask you to think about that as you hear the evidence, because one of the issues, of course, is where was Mr. Zimmerman going? Was he trying to track down Trayvon Martin? Or was he headed back to his car or somewhere to meet the police? We know from the other evidence that this is where it started. And this little flashlight was found. This is circumstantial evidence, if you will, that this is in fact where it started. Not somewhere down here or somewhere else, but this is where George Zimmerman got punched in the face and dropped his key as he was headed back to his car. There was the fighting, it went on down this way, the screaming, and then John Good saw Trayvon Martin on top of George Zimmerman right here. And when he went back inside, just a few seconds later, the shot was fired. The shot that could only have been fired in this position. There's obviously about the voice on the recording, the voice that's screaming for help. As I mentioned before, it doesn't seem as though there's a lot of dispute that that's what happened, that someone was screaming for help. So the idea would be, if possible, to learn, certainly valuable to the case, who was that? We know from Officer Tim Smith that when he arrived on the scene and was speaking with Mr. Zimmerman about what had happened, that Mr. Zimmerman told him right then, right afterwards, I was yelling for help and no one helped. So that's evidence. That's evidence that Mr. Zimmerman was yelling for help. He was the one with the injuries, of course. And common sense might suggest that the person yelling for help is the one being injured, as opposed to being the person on the top. But there's more than that, obviously. First of all, a question is, can science tell us who was yelling for help? And the short answer is no. The voice sample was submitted to the Federal Bureau of Investigation Digital Laboratory at Quantico. Their senior scientist is a fellow with 30, 40 years experience named Hirotaka Nakasone. And Dr. Nakasone personally evaluated and reviewed, examined the recording, and said, there's not enough sample here. After you get rid of all of the extra stuff, the masking, people talking over top, noise, and reduce it to just the sounds that could be subject for some scientific analysis, he said there was only about 2.5 seconds, and there was nothing they could do with it. They tried, but there was nothing they could do with it. It's not suitable because of the length, but even more so, it's not suitable because of the nature of the screaming. In voice identification, you can't do a valid voice identification with someone that's screaming. It's either a waste of time or the results are unreliable, is the bottom line. And they know enough at the FBI to say, no, we can't. We wish we could, but we can't. So therefore, there is no scientific voice identification evidence on that. However, there is some things that science can tell us. One of them is, for example, it's accepted in the scientific community that you cannot tell someone's age by screaming. You can't listen to someone that's screaming and know how old they are. Because of what the fear and the panic in a life-threatening situation does to you, it changes everything. There's nothing predictable. A 50-year-old man can sound like a 14-year-old girl. So there's nothing there either that helps scientifically to know whose voice it is. So what we're left with then is people that may be familiar with the voice, and whether or not someone that knows the voice can say, I've known that person their whole life. I've known them in every situation since they were little, laughing, crying, yelling, what have you. And I hear that and I recognize it, and this is who I think it is. And there's evidence about that in this case too. I'll give you an example. George Zimmerman's uncle, Jorge Meza, is retired military and a sworn deputy with the Orange County Sheriff's Office. He was at home working on his computer or something, and his wife had the TV on in the background. Mr. Meza didn't know necessarily what she was watching, except it was the news. And he heard the scream over there working on the computer. He heard it playing on TV. And he will tell you he immediately, without question in his mind, knew that was his nephew George. Likewise, there are family and friends of George Zimmerman, co-workers, who listened to the recording, either on when it was played in the media or elsewhere, and said, that's George Zimmerman screaming for help. without naming them all or talking about it specifically, categorically, co-workers, friends, and of course some family. On the other hand, as one might expect, there will be witnesses to say that I've also listened to the recording, and that I think that that's Trayvon Martin's voice. I would expect his mother to say that. She certainly wants it to be his voice. I would expect that his father would say that, and perhaps other family members. But I think there's some things to know about that as the evidence unfolds. The event was February 26th, 2012, about 7 o'clock at night. As I mentioned, it wasn't immediately clear who Trayvon Martin was. Mr. Martin and Ms. Green weren't home, and Chad Johnson, the 12-year-old, didn't know something was going on. So it took a while for this to unfold. And then on, I believe it was February 28th, Investigator Chris Serino with the Sanford Police Department met with Tracy Martin and Brandy Green. Now, they'd met with them before, but this was at the Sanford Police Department for the purpose of reviewing where the investigation stood and to have the opportunity to play the recordings. I believe Mr. Zimmerman's call may have been played. There were other calls played of other residents that made a 911 call, none of which had the screams or the shot. But there was this one call, the call that we've heard here today with the screams in the background. And Mr. Martin and Ms. Green were sitting at a desk in kind of a bullpen area in the Sanford Police Department, and Investigator Serino was playing the recordings for them and having them listen. And played the one that you've heard here today with the screams and the shot, and played it through from beginning to end. And Investigator Serino then turned to Mr. Martin and said, "Is that your son?" And Mr. Martin lowered his head and said, "No, that's not my son." Brandy Green didn't weigh in on it. She didn't say, "Well, let's hear it again." Mr. Martin didn't say, "Let's hear it again. I'm not sure. I can't hear it very well." Said, "No, that's not my son." Indeed, Mr. Martin didn't tell Sabrina Fulton that he had heard the recording at the police department when he talked with her. And then, of course, more stuff started to happen in town. Things started to happen. George Zimmerman hadn't been arrested yet. There were press conferences. Indeed, after this event at the Sanford Police Department, Mr. Martin and Ms. Fulton hired a lawyer, a law firm, several lawyers, and a media consultant. Began to have press conferences. The community reaction became to building. In fact, there was a lawsuit filed to get the recording released because it was part of the investigation. Mr. Martin did not go back to the Sanford Police Department and say, "Can I hear it again?" His lawyer didn't do that. Ms. Fulton never contacted the police department and said, "Can I listen to the recording?" Instead, there was great public pressure on the city to release these recordings. The state attorney's office in charge of the case, Norm Wolfinger, he's the state attorney for this circuit, was contacted. He didn't want the recordings
No, I'm
released.
sorry, objection. This is contrary to our motion to eliminate that we heard last week.
Okay, and it's also a closing argument. Sustained.
Thank you. With this backdrop and the issue of the recordings being in the forefront, there was a meeting held. There was a meeting held on March 16th, I believe, 16th or 17th, where no law enforcement was present or allowed to be present at City Hall. Mr. Martin was there, Ms. Fulton was there, several of their family members were there, including their legal counsel, Mr. Crump and Ms. Jackson. And these recordings were played by the city manager and the mayor. They were basically taken out of evidence without law enforcement being present and played. And not played for each one by one, separate from the others, but were played all at the same time with everybody in the room. Mr. Martin said then, no, that is my son. And of course, Ms. Fulton and the others, powerfully impacted by that, now say that it is too, that that's Trayvon Martin. They have not involved themselves in understanding the evidence of the case, though. They haven't looked at what we've already talked about.
Is closing argument sustained?
So, another person, though, that identified this voice unmistakably as George Zimmerman is Eloise Dilligard. We talked about her earlier. She was George Zimmerman's neighbor. She was the woman, an African-American woman, who saw Mr. Zimmerman's truck and said, I'll ask George. She knows Shelley Zimmerman. She knows George Zimmerman. And when she heard the recording, frankly, given the context of this case, as tough as it might be for her to say that, she said, yes, I know it. That's George Zimmerman. Excuse me. I'd like to talk about for a moment, and I promise I'll be done pretty soon. This is a lot of information. Even though the event itself only took a few minutes, there's a lot to know about it, a lot of very real evidence. And then there are legal considerations as well. And you've already heard part of the instructions on second-degree murder, the elements of second-degree murder. And you've also heard part of the instruction on self-defense or justifiable use of deadly force. The way that gets to you is through jury instructions. The statutes and the rules and such are distilled into a form that's supposed to be relatively easy to understand and instructed insofar as self-defense is concerned.
I don't object to this as being an improper opening statement.
Okay, the purpose of opening statement is to give the jury an overview of what counsel believes the evidence will show. Comments on what the evidence was is for closing arguments. The objection is sustained.
Yes, Your Honor, I understand. My point, though, is this. A consideration that you may properly have in a case involving self-defense are the physical abilities and capacities.
I don't object.
Sustained. Well, counsel can state in opening what you expect the evidence will show. Any comments on the evidence or the law is for closing argument.
Yes, Your Honor.
Thank you.
May we talk for a moment about the physical abilities and capabilities of Trayvon Martin and George Zimmerman? Mr. Guy suggested to you a couple of things, and I'd like to respond and point some things out to you. Insofar as Trayvon Martin is concerned, he was 5'11", around 160 pounds. He was a former football player. He used to play linebacker, and he was very good at it. He knew how to give a hit and take a hit, as anybody does that plays football. He also knew from John Good's testimony that he knew how to mount someone so as to incapacitate them. Mr. Guy mentions that George Zimmerman had some training too. Yes, let's talk about that for a moment. George Zimmerman, some years back, was quite heavy and wanted to get in better shape, lose weight. Regrettably, after living in hiding the last year, following this event, he's put it back on. But in February 2012, he was considerably lighter than he is now. He was around 200 pounds. And it was a result of diet and exercise, which I'm told is the only thing that ever works when it comes right down to it. He worked full-time, as I mentioned. As Mr. Guy mentioned, he also went to school. He was in college. And when he could, he went to the gym. The gym is called Cocapelli's Gym. It's in Lake Mary. The guy who runs it is a fellow named Adam Pollock. Adam Pollock is a skilled boxer. I think he was a professional fighter at some point. Understands martial arts. Was a corner man in fights. When people get hit and hurt, they fix them up. In fact, he saw George Zimmerman within a day or so of this event in February 2012 and saw the injuries of George Zimmerman being struck. But Adam Pollock runs the gym. He knows, because people pay him each month, who's current. He doesn't know, though, who goes and when they go. Although he teaches some of the classes, he doesn't keep attendance, but he knows George Zimmerman was there regularly and that George Zimmerman was accomplishing his goal. He was losing weight through diet and exercise. George Zimmerman was fitting in the classes that he could, not because he had a special interest in anything, but because it accommodated his busy work schedule and school schedule. And they included a grappling class, and a boxing class. In the boxing class, as Adam Pollock will tell you, George Zimmerman never made it past standing and hitting the bag. Adam Pollock considers him to be not athletic, and Mr. Pollock knows an athlete when he sees one, not skilled. He uses the vernacular soft, that George Zimmerman is soft, and that he never considered letting him get in a ring with anybody. Did he go to class? Yes. Did he say even to Lynn Folgate, yes, I do this kind of exercise, this my tea martial arts thing, but not because he was any good at it. You'll be allowed to consider that evidence too when you look at the physical abilities and capabilities of the two individuals involved in this. One of the things that is important, of course, is responsible gun ownership. I told you a little bit about the evidence about George Zimmerman being a responsible gun owner. There's no evidence whatsoever from any of the people that the FBI or FDLE interviewed that George Zimmerman was trigger happy, that he was reckless. In fact, most people didn't even know he had a gun. He didn't brag about it, didn't tell people, didn't show it. But he got a permit in 2009. They lived in this community since 2009, and there was a neighbor that was not a responsible dog owner. Had a big dog, a powerful dog, and an aggressive dog. And the dog would get loose, the dog would come into the backyard and harass people, including George Zimmerman's wife. And like a responsible citizen would do, the animal control was called a couple of times. The dog was still not on leash, and the owner wasn't being cooperative. So what do you do when you've got a big, aggressive dog that's not on the leash? Pepper spray? That was an idea that Mr. Zimmerman considered. You get pepper spray, but that doesn't work. You don't have enough time, and you're probably more likely just to make them mad. So what do you do about it if you're in that situation? If you're living in a community like that, you only have one choice. You either make yourself vulnerable or you get a gun. And if you get a gun, you should get a license.
Objection, Your Honor. Again, I'm going to object to this as being improper.
I'll
Sustained.
rephrase. George Zimmerman got the permit, took the class, learned how to use the firearm responsibly, was good friends with Mark Osterman, the air marshal told you about, who told Mr. Zimmerman what kind of gun to get for personal protection. You want a double action only gun without an external safety, because if you need it, whatever that situation is where you really, really need it, when seconds truly matter, you don't have time to think about taking the safety off. You don't have time to think about racking the gun.
Your Honor, again, same objection.
Sustained.
If you're going to have it, it should be exactly the way Mr. Zimmerman was carrying it. So, Your Honor, I would like to address the jury briefly on the burden of proof and the standard of proof.
Judge, I would object to that as being improper for opening statements.
Opening statement is for counsel to tell the jury what they expect the evidence will show. Argument as to the law is for closing argument.
Your Honor, would the
At the close of the evidence, the court will instruct the jury on the law that's to be applied, and counsel at that time may argue how that law applies to the facts. This is opening statement. The objection is sustained.
Would the court remind the jury that it's the burden of the state?
Okay. The court will instruct the jury at the time of when the evidence is closed as to the law that applies to this case.
You've heard some of that already in the jury selection and the general voir dire about whose burden it is and what the quality of the evidence has to be and what self-defense is.
Judge, again, I had to impose the same objection. I apologize.
Sustained.
I only ask that you remember that, what you've already known, plus this. If I've heard it once, I've heard it 1,000 times, that Trayvon Martin was unarmed. What the evidence will show you is that's not true. Trayvon Martin armed himself with the concrete sidewalk and used it to smash George Zimmerman's head. No different than if he picked up a brick or bashed a head against a wall. That is a deadly weapon. And the law is very specific about when you can defend yourself when the other person has a deadly weapon. Please listen to all of the evidence. You're going to be with us. We're going to be with you for a while. Maybe not as long as we first thought, a couple of weeks, I hope. And that you understand that the prosecution goes first. They put on their case first because it's their burden. So just keep the open mind, no matter how passionate the opening might be, until you hear all of the evidence. That's all I can ask. Thank you.
Thank you, Mr. West. Ladies and gentlemen, we need to take up a brief matter outside your presence. So if you'll please put your notepad